Welcome to the deep dive. Today we are tearing into the absolute core mechanics of how contracts actually work. We're not just asking who breached. We're asking a much more fundamental question. Did the duty to perform a promise even kick in to begin with?
That's right.
Our mission is to master the rules around conditions, those events that can trigger or even discharge an obligation, and then look at the remedies you have when performance is threatened.
Exactly. And for you to really get this,
Huh.
we need a clear roadmap. We're going to start by classifying conditions.
Okay.
Precedent, subsequent, concurrent. That label is so powerful because it tells you who has the burden of proof in court. Then we'll dive into how courts can excuse a condition. We'll look at interference and unfair forfeiture. And finally, we'll get into what happens when performance is threatened early on, looking at anticipatory repudiation and the UCC's big safety net, the demand for adequate assurance.
All right, let's start with the basics. I sign a contract.
Yeah.
What are the three foundational ways my obligation might be conditioned based on, how it operates?
The three types are condition precedent, condition subsequent, and concurrent condition. It's all about the timing.
Okay, so lay out the first two. What exactly is a condition precedent, and how is it different from a condition subsequent?
So a condition precedent is some event that has to happen before a party's duty to perform matures.
Like a gate.
That's a great way to think of it. Until that gate opens, the duty is just dormant. A classic example is buying a house being conditioned on you getting a mortgage. No mortgage commitment, no duty to buy.
Got it. And subsequent?
A condition subsequent is the opposite. It's an event that happens after the duty has already matured, but it basically terminates or excuses that duty.
I get the timing, but why should a lawyer or anyone in business really care what label a court uses? What's the practical impact?
Oh, it can literally determine the winner of a lawsuit before you even get to the substance. It's all about the burden of pleading and proof. If you are the one trying to enforce a promise, you have to prove the condition precedent happened. But if you're the one trying to get out of a duty, you have to prove the condition subsequent happened. In a closed case where the evidence is 50-50, whoever has the burden of proof loses.
It's the whole ballgame.
The whole ball game.
Now, where did these conditions come from? Are they always written out explicitly?
Oh, absolutely not. We classify them by their source. You have express conditions, which are obvious. They use trigger words like subject to, provided that, if.
Right.
Then you have implied conditions. These come from the party's conduct or just the context of the deal. For example, a construction contract implies the owner has to give the builder access to the site.
Yeah, it just makes sense.
It does. And finally, there are constructive conditions. These are the most interesting. They're judge-made. A court imposes them to ensure a fair and orderly exchange, like saying payment and delivery of goods should happen at the same time. This is the legal tool that pulled contract law into the modern era.
Okay, let's shift to the excuse doctrines. A big one is interference. What's the basic rule when a party interferes with a condition that their own duty depends on?
The fundamental rule is pretty straightforward. A condition is excused if the person who benefits from it actively prevents it from happening.
So you can't cause the failure and then use that failure as an excuse.
Exactly. It all comes down to the implied covenant of good faith and fair dealing. You just can't hinder the other party's performance.
Let's apply this to a case that illustrates the rule in, frankly, the most chilling way possible. Foreman State Trust and Savings Bank v. Tauber. It involved a prenuptial agreement. A large payment was promised to the wife, but it was conditioned on her surviving her husband. Then, the husband murdered his wife.
It's a shocking set of facts.
Let's analyze Tauber. First, what are the legally dispositive facts?
Okay. A prenup made the husband's promise to pay conditional on his wife surviving him. That's a clear condition precedent. The husband, the promiser, then actively and willfully caused the failure of that very condition by murdering her.
And what was the core legal issue?
The issue was whether a promiser who intentionally prevents a condition from occurring can then turn around and use its non-occurrence to get out of his contractual promise.
What rule of law did the court apply? Can you state the full black-letter rule and break it down for us?
The court applied the rule that a condition is excused by hindrance. And that rule has three elements. 1, a conditional promise exists. 2, the promiser engaged in some voluntary action. And 3, that action is what made the condition fail.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first and second elements, the promise and the promiser's action?
Well, the first element was easy. The conditional promise to pay was written right there in the prenup. For the second element, the husband's voluntary, willful act, the murder, was obviously the action that caused the failure. It's a total breach of the implied duty not to interfere.
Understood. Now, for the crucial third element, did the court conclude that the husband's act directly prevented the survival condition from occurring?
Yes, absolutely. His actions actively and intentionally prevented his wife from satisfying the condition. The causation was direct and undeniable. So because the promisor himself caused the failure, the third element was met. The condition was excused.
And after analyzing all those elements, what was the court's final conclusion?
The court delivered what you could call the ultimate form of legal justice. It refused to let a wrongdoer profit from his own horrific act. It enforced the promise. The husband's estate had to pay the wife's estate, even though the survival condition literally failed.
That case is unforgettable. Let's try a commercial hypothetical now. Imagine a builder on a really tight deadline. The contract has an implied condition that the owner will provide access to the site.
Okay.
But the homeowner keeps changing the locks, blocking the driveway, just actively getting in the way. The builder misses the deadline. What happens to the builder's promise to finish on time?
The homeowner's interference, that failure of the implied condition of access, would excuse the builder's own duty to finish by the deadline. The builder is discharged from that time condition and could probably sue for damages for the work they did and any lost profit. You can't interfere and then sue for non-performance.
We've covered active interference.
Right.
But what if you decide you don't care about a condition anymore? Let's talk about waivers. What's the single biggest limit on what kinds of conditions you can just waive away?
This is such a critical distinction. You can only waive ancillary conditions.
Ancillary.
Meaning not a material part of the agreed-upon exchange. The policy is one cannot waive himself into a duty to make a gift. You can't, for instance, waive the condition of payment for a car you're selling. Payment is the whole point of the deal.
That makes perfect sense.
Yeah.
Let's test this with Clark v. West. A publisher contracts with a law professor to write a book. The base pay is $2 a page, but there's a bonus of $4 extra a page, conditioned on the author not drinking alcohol while working. The author drank a lot, but the publisher knew and kept telling him, "Don't worry, we'll pay you the bonus anyway."
A classic waiver scenario.
Let's analyze Clark v. West. First, what are the legally dispositive facts?
Okay. The contract had an express condition for a bonus payment. The author had to abstain from alcohol. The author breached that condition. But the publisher, knowing full well that he was drinking, repeatedly waived the condition and promised to pay the bonus.
So what was the core legal issue?
The issue was whether that abstinence condition was ancillary, something the publisher could just waive, or if it was a material part of the whole bargain.
What rule of law did the court apply? Break it down into its elements for us.
The court applied the waiver rule. A condition can be waived if it's ancillary. The elements are: 1, the promisor voluntarily gives up a known right, and 2, that condition is not a material part of the exchange.
Wait, the publisher knew he was drinking and still promised the bonus. How did the court look at that second element, the materiality of the new drinking clause?
The court reasoned that the fundamental purpose of the contract was to write the books.
Right, not to control his personal habits.
Exactly. The abstinence clause was just a means to facilitate good writing. Since the author delivered a satisfactory book, his sobriety or lack thereof was ancillary. The material exchange was the book for the money.
And after analyzing all the elements, what was the court's final conclusion?
The court concluded that because the condition was ancillary, the publisher had the power to waive it. And by promising the bonus with full knowledge, he did waive it. He had to pay the full $6 a page.
Okay, let's shift from an intentional waiver to the doctrine of forfeiture. What's the guiding principle that makes courts sometimes excuse a condition even if no one waived it?
The core idea is that equity abhors a forfeiture. Meaning courts are very reluctant to enforce a condition, especially a technical or procedural one, if it would cause a massive unfair financial loss, a disproportionate forfeiture.
Let's look at J&A Realty Corp. v. Crosby Chelsea, Inc. This is a huge case on this. A commercial tenant, a restaurant, failed to give the required 6-month written notice by certified mail to renew their long-term lease.
A technical mistake.
A huge one. Enforcing it meant the tenant would lose years of improvements, all their customer goodwill, everything. Let's analyze J&A Realty. First, What are the legally dispositive facts?
So, a commercial tenant failed to meet an express procedural condition timely written notice to exercise a 24-year lease option. This mistake put them at risk of losing a massive amount of money in investments and goodwill.
And was the core legal issue?
The issue was whether the court should use its equity power to excuse the failure of this notice condition to prevent a disproportionate forfeiture. And if so, how does it balance the harms between the landlord and the tenant?
What's the rule the court applied? What are the elements?
The rule is a balancing test to avoid disproportionate forfeiture. The elements are 1. The failure of an ancillary condition. 2. The resulting loss is a disproportionate forfeiture. And 3. The court has to balance the harm to the party seeking excuse, the tenant, against any harm suffered by the other party, the landlord.
So how did the court apply that proportionality element? How did it compare the tenant's potential loss to the landlord's?
The forfeiture was obviously disproportionate. The tenant was facing the loss of years of investment in their entire business. The landlord, on the other hand, just missed a procedural notice. The financial disparity was immense.
But the landlord has rights too. What about the third element, protecting the landlord's position?
That's the crucial part. The court noted that if the landlord had already relied on the tenant's failure, say he'd signed a new lease with someone else, that reliance would be a significant harm that has to be weighed in the balance.
So it's not an automatic win for the tenant.
Not at all. Equity doesn't just transfer the injustice to the other side.
So what was the court's final conclusion?
The court actually reversed the lower court's decision, which had automatically excused the condition. Instead, it remanded the case. It sent it back down and told the trial judge to specifically figure out how much the landlord was actually harmed before deciding if equity could excuse the condition. It modeled the balancing test for all future cases.
Let's shift gears now to when a breach is just threatened. What is anticipatory repudiation, and why can you sue someone for a breach that hasn't even happened yet?
Anticipatory repudiation is when one party clearly and unequivocally renounces their duty before performance is due. It has to be a definite and unequivocal statement.
Not just a hint.
Not just a hint. The policy for allowing an immediate lawsuit comes from an old case, Hoster v. de la Tour, and it's about efficiency. It lets the non-breaching party sue immediately and, more importantly, mitigate their damages. They can move on and find another deal.
But there's a big risk there, isn't there? If you guess wrong and they weren't really repudiating, you become the one in breach.
That's exactly the danger. The renunciation has to be ironclad. Which brings us to the safety net. What if the threat is fuzzy? What if you're just really worried but don't have a definite repudiation?
That's the key question. How can you protect yourself without accidentally breaching the contract yourself?
That's where UCC Section 2609 comes in. The demand for adequate assurance. If you have reasonable grounds for insecurity, you can make a written demand for adequate assurance, and you can suspend your own performance while you wait.
And if they don't give it?
If they fail to provide that assurance within a reasonable time, the UCC says up to 30 days, that failure is treated as a repudiation.
Let's test this with Pittsburgh Des Moines Steel Co. v. Brookhaven Manor Water Co. A seller of a water tank got worried about the buyer's finances. They demanded the full price, $175,000, be put in escrow immediately. Even though the contract said payment was due 30 days after the tank was finished, when the buyer refused, the seller stopped working. Let's analyze PDM Steel. First, what are the legally dispositive facts?
The seller of a water tank, worried about a rumor about the buyer's financing, demanded the buyer put the full price in escrow. This was a new term, not in the contract. When the buyer refused, the seller stopped working.
And what was the core legal issue?
The issue was twofold. Did the seller even have reasonable grounds for insecurity under 2609? And was demanding an escrow deposit that went beyond the contract an adequate demand for assurance?
What rule of law did the court apply? What are its elements?
The rule is from UCC 2609. It has two main elements. One, you have to have reasonable grounds for insecurity. And two, the assurance you demand must be adequate and can't be used to extort new terms or get more than the contract gave you.
So how did the court apply that first element? Did the seller have reasonable grounds for insecurity?
The court said no, not even close. There was no evidence the buyer's financial status had actually gotten worse. Worrying about them not yet having secured a future loan was just rumor and speculation. That's not enough.
So since the grounds weren't reasonable, the whole thing falls apart. But how did the court view the adequacy of the demand itself, the escrow?
The court found the demand itself was improper. By demanding the full price in escrow, the seller was trying to force a brand new condition on the buyer. The assurance you ask for has to be related to the contract. It has to be adequate, not exploitative.
And after analyzing all the elements, what was the court's final conclusion?
Because the seller had no reasonable grounds and made an excessive demand, their decision to stop working was unjustified. The court ruled that the seller, PDM Skeel, was the one who had actually repudiated the contract. It's a huge lesson. Use this tool wrong, and you're the one in breach. #tag exam framework synthesis. All right, to bring this all together for you, here's a 6-step diagnostic checklist to analyze any performance failure problem.
Okay, let's hear it.
1. Identify the failure. Did a party fail a duty, or did a condition fail to happen?
First question.
2. Condition or promise? If it was a condition, what kind? Was it precedent, which matters for the burden of proof, or was it subsequent? 3. Check for excuse by hindrance or repudiation. Did the other party get in the way, like in Tauber, or did they just renounce the deal earlier? 4. Check for insecurity. If the renunciation was vague, did the worried party make a proper demand for adequate assurance? Remember the test. Written, reasonable grounds, and not demanding excessive new terms. 5. Check for excuse by waiver or forfeiture. Was the failed condition ancillary? If so, did the other party waive it? Or would enforcing it cause a disproportionate forfeiture, which means you have to do that balancing test?
And the last step.
6.
Cure.
If it is a breach, does the breaching party have a right to cure the problem, especially if time hasn't run out on the contract?
That checklist is a fantastic tool. It really shows the huge shift in contract law, from those old, rigid promises to our modern system where one party's failure can immediately excuse the other. I think the big takeaway is know what you can and cannot waive. Don't touch the core of the deal.
And that leads to the final thought I want to leave you with. Courts are in this constant struggle, this balancing act between two powerful ideas. On one hand, you have holding people to the literal black-letter text of their agreement.
What the contract says is what it says.
Right, and on the other hand, you have equity using doctrines like anti-forfeiture to prevent massive, unjust financial losses from a technical mistake. And the question to ponder is this. Which side of that balance stripped text or economic justice is actually more important for making commerce run smoothly and fairly? It's a tension that's at the heart of contract law every single day.